to the training. Welcome to the training on CalWORKs and CalFresh Overpayments. I am Grace Gallagher, the directing attorney at CCWRO. Unfortunately, Kevin Aslanian became unavailable, so I am pitch hitting for him today. I am assuming a very basic information, so if I get too basic, please forgive me because I want to make sure everybody understands what I am talking about. So let's begin with the next slide. Click, got it. An overpayment is a county determination that the recipient received more benefits than what the assistance unit, AU in CalWORKs, or household, HH in CalFresh, was entitled to receive. The county must issue a notice of action for the alleged overpayment overissuance to the AU or H household before taking action to collect. Now, overpayment and overissuance basically means the same thing. Sometimes it's referred to generally as an overpayment. And what happens is when CalFresh households also receive CalWORKs, it's called categorical linkage. So what generally happens if there is an alleged CalWORKs overpayment, there will also be a CalFresh overissuance. The general exception is when the overpayment is caused by excess resources, and I will explain that later as we go ahead. Next page. So causes of the overpayments is if you are over income limits, which is established by the Department of Social Services for both CalWORKs and CalFresh on an annual basis. The failure to comply with the income reporting threshold, the IRT. And basically what the IRT is the amount that you must report if your income exceeds the IRT, and you must report it within 10 days. And how you know about it is that each year the county will issue or every 6 months when you make your report, the county will issue a notice of action saying this is the amount of your IRT for the interim period. A CalWORKs case with income exceeding the IRT may be discontinued, or the grant may be decreased depending upon how much income is being reported. The next type of overpayment is over resources, and it's CalWORKs, but no longer for food stamps. So the resource limits for CalWORKs is $11,634 or less, or $17,452 if a member of the assistance unit is disabled or over 60. And now, finally, the car is exempt up to $32,045. Another type of overpayment is if there's a change in the household composition. This used to be really big in the 60s and 70s. A county would say that there's a man in the house, presuming that it's the father. Basically, what this means is that somebody has left the house, left the assistance unit, no longer lives with the assistance unit, but the individual has not reported that he has left the house. That means that the grant size is larger than what it actually is, and that differential is what causes the overpayment. The allegation that children are not in the home, or that the assistance unit is no longer eligible for benefits. If the assistance unit is receiving child support direct payments and they fail to report it to the county, that can cause an overpayment. The CalWORKs overpayment regulations are basically MPP section 44-350, which you can look if you need additional information. Next slide, please. So how does the county discover that there's an overpayment? Well, as you see, there's various ways. One is the income and eligibility verification system. This is an umbrella term used for many computer matching systems that assist in the eligibility determination for all applicants and recipients in CalWORKs food stamps Medi-Cal programs. And this includes matches with the Employment Development Department, Social Security Administration, and the systematic alien verification for entitlement, which will identify satisfactory immigration status, as well as the FTB asset mix. Another type is the new hire registry. So when employers hire new staff, they are required to report any newly hired or rehired employee within 20 days of the start of work date. So that if you have just gotten a job a month ago and you apply for CalWORKs or CalFresh and you don't report being employed, then it will probably be picked up at some point with the new hire registry. Also, bank records may be used to determine overpayments. Also, the SAR 7 semi-annual report or the annual report, where you have to make reports for your total assets and income, as well as the number of people in the household or assistance unit, can be used to determine an overpayment. And also any other EDD reports that may exist. Next slide, please. So the CalWORKs collection methods are tax intercept through using either the Franchise Tax Board or the federal, or if you're have filed for income tax in some other state, they can request a intercept by grant adjustment. And that basically is reducing the amount of the monthly grant that the individual will receive or the family will receive to recoup the overpayment amount. The county can take you to court on a civil to request a civil judgment, and then you would have to pay the civil judgment, or they could request that you voluntarily pay them back out of any other funds that you may have. Next slide, please. The CalWORKs responsible parties are the adults in the assistance unit at the time of the overpayment, and also any children after they've turned 18, only if the overpayment has not been paid. Next slide. The types of CalWORKs overpayments. 3 types: administrative error, client-caused error, and intentional program violations, IPV, which we refer to as fraud. And I will discuss each type a little bit more. Next slide, please. For administrative errors, This is a type of overpayment where the county caused the overpayment, where the assistance unit properly made a complete report. They reported all of their income, resources, members of the household, and the county failed to accurately budget the reported income. They did not consider resources, or the county failed to remove members of the assistance unit. Often they will call this either an administrative error, or they will categorize it as a client-caused error. And you must be aware of the difference, because the administrative errors creates a different set of relief from the client-caused error. Next slide, please. So the CalWORKs excess property overpayments occur when the county determines that a property is worth less than the resource limit. And they generally use as common property values for both the property, if there's real estate, or personal. They'll look at how much the resale value is by going to Goodwill or looking on eBay or any of the other stock websites that sell used equipment. The recipient does not have to agree with the county's valuation. If you can demonstrate that the property is worthless or at a decreased value, then you can go to an administrative hearing to fight this. And basically what happens is that you get documentation, you get witness statements. If it's real estate, if the county says the value is $350,000, because that's what the local real estate sales are, but you can prove that the house is unlivable or gutted, then and basically it's not the house that you're living in, it's the house that you own outside of where you're living, so that you can show that the value is much less than what the asset is. Again, it's like the car. If they have a car value of $50,000 and it doesn't have an engine, it doesn't have the wheels, it doesn't have the suspension, it doesn't have anything else, you can show that the value is, whatever, much less than what they're saying it is. There are also property exclusions to resources, and primarily it's devices used by disabled members, or it's not available to the family. And there are additional property exclusions that you can find in the regulations. Now, you will not have this problem in CalFresh, because for the most part, the CalFresh categorical recipients do no longer have a property limitation. It's only when you are receiving CalFresh individually that you would have a resource limit. And there's another category of people that would have to meet the resource limits for CalFresh. Next slide, please. So the CalWORKs overpayment defenses is basically the primary one for administrative error is equitable estoppel. And the notes from the Training Bureau is very good and gives an overall view of what they consider and what they have examples of what is and what isn't equitable estoppel. And if the equitable estoppel applies, the overpayment becomes uncollectible. Now, equitable estoppel has 5 elements to it. And these are the party, which is the county, to be estopped must be advised of all the necessary information. That is, the recipient must have fully reported all the information to make a correct determination of aid or eligibility. The second is that the county must intend that the conduct be acted upon or must so act that the party asserting the estoppel had a right to believe it is so intended. And basically what this means is that the county will send you, you make a report, the county evaluates it, and then they'll say, okay, this is the amount of your benefits that you will have for the next 6 months. And because this conduct is reasonably relied upon, that it's the accurate amount, then the recipient would meet the second step. The claimant must be ignorant of the true state of facts, which basically means that the claimant had no knowledge that the county committed an error in calculations of the benefits. And then the claimant must rely on the conduct to her injury. So if you get the wrong amount of benefits, and because you had more than you thought you did, then you have the right to, you have the right to rely on that difference. And you go out and buy like a new refrigerator or some other items that you would not have otherwise bought had you not received the difference. And then the fifth step is balancing the interests of the governmental agencies. And that basically means is they have the right to say, this is unfair to us to make us repay an overpayment, and the recipient should have to buy it. The general case for equitable estoppel is Lentz versus McMahon, 1989 case, and you can find it at 49 Cal 3rd at 393. The next equitable defense is laches, which is a doctrine in equity whereby courts can deny relief to a claimant with an otherwise valid claim when the party bringing the claim unreasonably delayed asserting the claim to the detriment of the opposing party. And it's also called estoppel by laches. And basically what that means is that the county waited too long to bring the action so that there are no case records or other documentation that the assistance unit can review in order to make a determination of whether the overpayment is correct or not. And this comes into the cow saws. There has been the conversion of, finally in October of last year, that all of the Cowing counties and C4 counties have become cow saws. And there has been a lot of documented cases where the transferred information from one program into CalSAWS is wrong. And that is creating some overpayments that should not exist or are wrong. The information is old. or not current. And so when you have an overpayment case, you really need to evaluate as to whether or not you need to file a hearing and complain about it. The next step is, let's go back, I'm not through, incorrect budgeting, where the QR7 had reporting mistakes. And this basically is where the assistance unit misreported, either intentionally or unintentionally, certain income, forgot to include income, forgot to, where the county, it could occur when the county thinks somebody has moved out, they moved out temporarily, but they're coming back. And that creates an issue. Or when the assistance unit transposes numbers. And that can be a major issue. And then the last defendant is or defense is the alleged fraud, where the county is alleging that fraud exists, that you intentionally misreported or underreported the situation. And the defense to that is that it was not intentional. Now, the important part about that is that I had a case in Yolo County where she had a public defender, and they went through the trial and they were getting almost to the sentencing phase. And she came to me and I said, file for a fair hearing. We went through the fair hearing process. The ALJ found that the overpayment was administrative error, which totally guts the fraud allegation. She went to the public defender. Public defender said, it's too late to do this. You're going to be sentenced next week. I told her, go to the assistant district attorney. So we talked to the assistant district attorney, taking the hearing decision from the ALJ. And at the next sentencing hearing, the assistant district attorney requested that the case be dismissed in the interest of justice and reverse the fraud conviction because it was not. So just because there's alleged fraud does not mean that you should not evaluate the case fully. And further, that brings me another point, is that oftentimes the public defender does not know about the regulations for CalWORKs, CalFresh, and the others. They use case law, they use the criminal statutes, and that's it. So if you have a client who has a public defender, you might decide to work with the public defender to minimize or eliminate the penalties in the case. Next slide, please. So how do you get CalWORKs fraud? Well, unfortunately, the worker can refer suspected fraud cases. And basically, there's no standard that counties have to require the worker not to refer suspected cases. It's just, it can be as small as, I don't like the client. I know the client is doing something wrong. I'm going to refer the case to fraud. And the fraud unit can either be within the county welfare department. Some counties have contracts with the local district attorney's office to investigate. So if a worker does report or refer to the fraud. Basically, the fraud investigator will contact the assistance unit and say, hey, come in, let's talk about this. We can resolve the matter. No biggie, just tell us what happened. As an advocate, tell your client, do not talk to any fraud investigator or anyone at the county welfare department. And unless they have a search warrant, do not let them in the house, because whatever you say will probably be twisted. If you have the ability, tell the client to say, well, if you want to meet with me, I need my attorney or representative to come with me. And then you have minimum control, but I would not recommend that at all. So once a fraud investigator is convinced that there is fraud, it goes back to the county. And the county can then choose to either bring the criminal case as a felony or as an intentional program violation action. And basically, if it's a criminal case, they will have multiple counts: fraud, perjury, failure to whatever. And I've seen as many as 20 counts that are then reduced during the process. So you need to make sure the client understands that trying to pay it back will not stop a fraud prosecution, or stopping benefits won't help, because it's the intentional factor that the county is looking at, and the amount is not going to help. And if you decide to have an administrative hearing, be very, very careful. Don't allow the client to testify necessarily, because it's self-incrimination, and whatever they say at the hearing can go to the criminal case. And then the burden of proof is on the district attorney. Next slide, please. So if you go to an IP, and basically what happens, the county will determine whether they're going to file as criminal or as an intentional program violation. And I have the site, and the sites for the CalWORKs IPV is on the screen. And it's a different process than the regular hearing process that you're used to for overpayments and underpayments and the like. So it's a special hearing. The individual does not have to appear. The attorney or representative can appear on the individual's behalf and present any evidence they have in order to reduce the amount of the IPV, or to try to say that the violation was not intentional. And if the claimant loses the IPV hearing, it will result in both an overpayment and a period of disqualification for the disqualified individual. Basically, the first violation is that the individual who is determined to be responsible for the overpayment, that's the disqualified person, is not going to be eligible to receive benefits for 6 months. On a second violation, it's 1 year. On the third violation, it's lifetime. So basically what this means is that if you have an assistance unit of 5 with a disqualified person, then the disqualified person's income and assets will be counted to determine the continuing benefits. But instead of being an assistance unit of 5, it will only be an assistance unit of 4, because the disqualified person is not included in the assistance unit. So not only will you have the individual's income and assets counted, but you will also be below your probable needs for the maximum aid payment. Next, please. So, okay. So, the one big difference for the CalWORKs and food stamps overissuance is that the overissuance for purposes of resources does not exist. Because, as I said before, in California, if you are categorically eligible, then there will be no resource limit for receipt of CalFresh. And that is fairly big. However, you would still be charged under the CalWORKs. So for CalFresh, there's 3 types of overissuances again. And it mirrors what the CalWORKs has. You have the administrative error overpayment. You have an inadvertent household error and the intentional program violation. For agency errors, they have 36 months to recoup. And there is no recoupment in any month where, for CalFresh, where they've benefits is $35 in the allotment. And the maximum collected for the county error is 5%. And that has been because of the case of Lumalai versus Sins. And let's see. Where is that? And you can look that up. And it's basically the only type of equitable that you have. Equitable estoppel is not a defense in CalFresh. So that major defense is unavailable. So even if it's an administrative error, they will collect it as an inadvertent household error. Next slide, please. So CalFresh administrative error is when, again, when the county made the mistake that caused the error. And basically what I'm talking about is that the county miscalculated whatever, which allowed the household to receive a larger grant than what they were entitled to. And then again, as I was talking about before, the Lomalai limitation of 5% of the grant, or $10, whichever is greater, for 36 months from the first monthly grant reduction. And that is, also all county letter 0059 and all county information notice ACIN instead of I-09-00. Next slide. So if the over issuance is client caused, an inadvertent house, say you made a mistake, you transposed numbers, whatever, similar to the CalWORKs. The CalFresh collected from the recipient's current benefits will be at 10% each month. However, the county can request that the client enter into an agreement to collect more. And for most clients, that is not beneficial. So, and they do not have to agree to provide additional funds to replace that money. Next slide, please. Similar to the CalWORKs IPV, the CalFresh IPV basically works similarly. Because CalFresh is a federal program, you will notice that the federal SNAP program has the authority for the IPV as well as the Department of Social Services. Again, the IPV have specialized hearing processes, and it's just they will send out a notice saying your IPV hearing will be at such and such thing. You need to determine if the person will go to the IPV hearing. You may or choose not to have the person attend. And if they do not attend, there should be no comment as to whether the individual was present or not present. Next slide. So the overissuance collection methods, the most beneficial and the one raised by a claimant or recipient is identifying underissuances with overissuances. For example, if you were underpaid or your grant was too low and you should have gotten more money, then you can offset that with any overissuances. However, that's going to come not from the county, but by the individual and the advocate. The rest of the methods are county/DSS operated. And one is tax intercepts from the Franchise Tax Board, lottery winnings, IRS returns. This county can refer the case to the Department of Social Services, and at a designated period, the Department of Social Services will submit the case identification information to the Federal Treasury Offset Program. And basically that allows the intercept of federal tax refunds, any unemployment compensation funds, or Social Security Administration, not SSI, but in any SSI, SSA benefits, or any other federal payments. And there is no time limit to recoup. Remember when I said with Lomali, it's 3 years or 36 months. Under TOP, there is no limitation. Generally, if you don't use TOP, again, the statute of limitations is 3 years from the date of overissuance is established. However, there is no intercepts allowed if the current allotment is being adjusted. So if the monthly benefits are already reduced, or you have just received a notice and you still have the 90 days to request a hearing and that has not expired, then they cannot take the money before that. And even if you go to the hearing, if there's been no final decision by the ALJ, the county cannot collect. And then there's actually the regular restitution is being repaid by other means. So they can, so next. So before they can do an intercept for an overpayment or overissuance, the county must issue a notice of action about the intent to refer the overissuance for intercept. It has to include the amount of the overissuance, that the individual has the right to contest the referral for an intercept, and provide the name, address, and phone number of the county's contact to contest the intercept, as well as the right to an administrative review at any time. And if there's any possible reasons to disagree with the proposed actions, you need to do it. Again, going back to CalSAWs, there was information that was sent from the old computer systems to the new computer systems that involves CalFresh overissuances that may have already been paid, that is, or no longer collectible. And they, county, are looking at the new households and, oh, by the way, we can do the intercept now because there's been no payment, there's no adjustment, there's nothing that is being actively collected. So we can send this for intercept. And that's a big reason for having this notice of action. And the client can say, no, stop, I've already paid it, I don't want it. Next slide, please. So how do you fight overpayments or overissuances? First, you need to ask for a hearing. And I know it's different with programs because they interview the client. And basically when CC DeBarrero interviews a client, one of the first steps is we go ahead and ask for a hearing. Because what happens is that once the claimant asks for a hearing, then it goes from the eligibility department to rehearings. And generally, rehearings are more willing to negotiate, more willing to provide information and documentation, and also assist in determining whether or not the proposed overissuance or overpayment is correct. Once you've analyzed the case prior to hearing, you need to gather any documents or witnesses to support the client's case. And that might take a long time. And sometimes if you're having to deal with another state, it can take time for governmental action to actually achieve success. So you need to identify what you need and who you need to talk to as soon as possible. You also have the right to look at the case file. And you really need to do that because you cannot rely on the county to provide exculpatory evidence that does not support the county's statement. So you need to go through and find whatever is helpful for you. And in looking at the case file, if the issue is an overpayment, by examining the case file closely and looking for any other information, you might find an underpayment or an underissuance that will go to offset the overpayment or overissuance. And it's really important to take your time. And I know there are counties that will say, oh, well, I will give you the information that you need for this. instance, this overpayment. No, I need to look at the entire documentation. I need all of it. And that may or may not be lengthy depending upon the county agent. So, but you need to go through that to provide an adequate defense. If the county does not have a case file, then they should lose the hearing. Again, goes back to latches, because you can't prove your client's case if you don't have access to the case file and what happened. Similarly, I've been talking about the records at the county welfare department as opposed to accessing the SIU files, which is the fraud units files. And there is a lot of problem with getting that. And they believe they don't have to provide the files because we're an agent for the district attorney's office and we have a right to withhold it. And that's a continuing fight. You need, if there is a criminal case, then again, you need to work with the public defender. Because if there's been overpayment issues in the past, what is in the client's case file may help what you can develop the case with the public defender. Because I've often seen what's in the SIU case file that the public defender gets through discovery in the criminal process is often incomplete or different from what is in the county welfare department's case file. So you need to be able to compare the two. Remember, the burden of proving any overpayment is on the county. And again, look for underpayments such as sanctions, wrongful sanctions, or transportation non-payments for working payment, or the failure to pay mileage as a possible source of any underpayment. Next slide, please. So the collection agency actions. The county can use their own agency, such as in Sacramento County, they have the Department of Revenue Recovery, or the county can be contracted with a third party, and that probably more often in a smaller county. Make sure that the underlying underpayment or overissuance exists when the collection agency sends the notice saying, you owe us, $50 billion. We want you to pay up by next week. Make sure that that's a legitimate overpayment and overissuance. Again, that's frequently wrong. Make sure that the notices were issued. If they say, well, we sent you 3 previous notices and you ignored them, make sure that the addresses were correct. Make sure that they actually sent them. And then you can challenge the county to prove its case. So, next slide. So, are there any questions? David?
No, if anyone, I think everyone's muted. If you did have questions, and we didn't hear them, it's because you're muted. So if you do have a question, go ahead and unmute and ask. If not, then awesome. We appreciate your attendance.
So,
Cecilia Marcado asks, what is IRT? Can you define IRT again?
So the IRT is the amount of income that the family can receive for the grant. It's a calculation that is dependent upon the AU size. And if, for example, if the county sends you a notice that your IRT is $600, then if you have get a regular income of over $600, you have to report it within 10 days. And it's the income reporting threshold is what it's called. Does that help you at any?
Okay, good. Okay, any other questions? You can throw them in the chat. You can also, I will send out the a copy of the slides that went out today to everyone. If you have any questions, you can email Grace, you can email us, you can go to our website, ccwo.org. Oh, there's one question. Phyllis Katz asks, did I understand correctly that if there's a CalFresh overpayment that has already become a tax intercept, there's nothing that can be done to pull it back? Or only that if there is an unpaid overpayment, that it can go to a tax intercept at any time? Do you want me to read that again to understand?
No, I'm looking at it. If the county had not followed the requirements for the tax intercept, I would file for a hearing, because before the tax intercept can be effected, the claimant must be given an opportunity to challenge the tax intercept and the amount of the tax intercept. And that would be, and basically what you would be arguing before is that they failed to give you notice and an opportunity to be heard. So, and again, and if there's an unpaid overpayment, if it's not being repaid, or if it's a inadvertent household error, if it's beyond the 36 months, then they can't collect. Once the period is done, so say you have a $10,000 overissuance for CalFresh, and you've been paying 10% out of your grant for 36 months. After that 36-month period, the rest of it becomes uncollectible. They cannot use a tax intercept. It's done, it's over. So it's on the county to make a determination. Now, if they send it to a treasury offset, then they could collect the entire thing, regardless of how long it takes. But they can't do it if they've been undone.
So let's see. Victoria Richard has a question, and I'm sorry, Victoria, I can't seem to get anyone's unmuted. So if you could post the question and then.
Oh, you cannot hear me?
Oh, there you are.
Yeah,
Hey,
yeah.
yes.
This is not Victoria, it's Veronique, but that's okay.
Oh, thank you very much.
Yeah, so I'm not an attorney, I'm a social worker working with Bay Legal and working with folks that are who are applying for SSI, SSDI. I just came across so I hope it's relevant, but because I'm not a legal, I don't have a legal mind, but what happened is that one of our clients was trying to, well, she told me that her GA had been cut off, her Medi-Cal had been cut off, but her CalFresh was still coming in. Anyways, Medi-Cal told us, and they have what they call a interstate match. In other words, it's a list that the agency receives throughout the states,
Mhm.
and to just show that clients may have maybe receiving benefits elsewhere in other states. So like outside of California. Apparently, her father had put her on benefits in Michigan, but she wasn't aware, so she hadn't touched the money. But now the burden of proof is on her.
Yeah.
And so I'm just, and she's been receiving, mind you, they took 9 months for them to realize on general assistance that she was on benefit in Michigan. 9 months. So is it something that she should be worrying?
Okay, remember, okay, so she was getting SSI.
No, she's not getting, we are applying for SSI.
Okay,
That's
but
going to take
what
a
were the
long time.
benefits that she was getting in Michigan?
So she wasn't quite aware that she was getting benefits in Michigan. She said she didn't touch the money. I think her father, probably for Medi-Cal, her father had her on Medi-Cal for some reason, but she never touched the money. So when Medi-Cal, the worker, told her that she was receiving benefits in Medi-Cal, she looked at me very puzzled and she says, "Oh, maybe my father put me on." Anyway, it may be a conversation outside this because I know that time is running.
Yeah, I mean, the thing about it is the one argument would be that the money is unavailable.
In Michigan.
Because it's in mid, and I still, it's what benefits were being issued and was it money? Was it a, Medicaid type program? I mean, what were the benefits that?
It would be general assistance. Yeah,
Okay, general
she's been
assistance.
receiving general assistance in San Francisco for 9 months
Okay,
while she's living in San Francisco for
right,
9
right,
months.
I understand. Okay, so basically, you would make an argument that it was unavailable and inaccessible to her because she didn't know she had it.
I see.
However, you also need to realize, so that would make it inadvertent, especially if you can get statements from the father and, well, I never told her, or friends, or whatever. And what happened to the money? I mean, when Michigan issued the benefits, where did they deposit it somewhere? Did they deposit it in the father's account? Was there a bank account for her in Michigan? I mean, that
Right. That
you
makes sense.
need to explore all that, where did the money go?
Yeah, right.
And also whether or not it was subsumed back to Michigan. At some points, if the money isn't used, it goes back. And also remember, for purposes of California, the GA program is a loan. So she would have to pay that money back anyway once she gets on SSI.
Oh,
So,
yeah, no, that's, yeah.
so that's, in a way, I mean, her big problem is GA fraud. And basically what you
Unintentionally, yeah.
Yeah, and that means that she didn't have access to it. He might have had a bank account, but if she didn't have any, any checks or a bank card in order to access that,
Mm-hmm.
and then that's plays into everything. The big problem also is that Michigan may be going after her for getting benefits while living in another state.
Right. GA here in San Francisco is, of course, asking for a proof of residency, and that should be easy to do because she's still in a shelter.
Yeah.
But right, maybe the father is getting the money, because otherwise, I would think that if they would see that she is not using her ABT or she's not using her GA, and the money is still on the card, that could be thousands of dollars. And I'm wondering, why would they not think, hey, where are you? Are you still breathing? Are you still living here? This is really kind of 9 months.
I mean, that's a big problem. I mean, in some ways, I would be more concerned about the Michigan case
Mhm.
because, you apply for benefits in Michigan but you're living in California and Michigan continues to pay. I mean, ay, 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 ay.
Yeah, but why would they continue to pay for 9 months? As I said,
Yeah,
they should have
yeah.
realized is that, well, she's not here anymore. She's not whatever SARS they have or verification that she is still living but 9 months.
Yeah, but the whole point is how, what is the process for reporting? What's the reporting requirements in Michigan? Is it
Mhm.
something, for each program, because in each state it's different. So, if she has had to do a monthly report to Michigan every month, who's been making those reports?
Right. Yeah, makes sense.
Is it daddy? And if it's daddy, then that kind of helps the GA case. If daddy is signing her name to the reports, then
Mm,
you're going to have a bigger issue and you're going to have to look. You'll probably have to have somebody to verify the signatures.
right. Oh boy. I
Yeah.
think we're
Yeah.
getting
I mean,
deeper in some issues, but like they are, was it somewhat related to overpayment? I guess it is.
yeah.
That's why I wanted to participate. I'm not an attorney, as I said, I'm a social worker, so I'm trying to understand all that legalese thing. But thank you so much, Grace, and David. I need to clock out. That was very useful. Appreciate it.
Thank you.
Thank you.
Thank you, everybody. Anyone have any more questions? I don't think so. I don't see any hands. Okay, well, thank
Thank
everyone for
you.
attending.
And have a great Friday, everyone. Have a great weekend.
Absolutely.
Get prepared because tax day is Monday. Yay.
Indeed. And I will send out a copy of the slide and recording of the presentation for all attendees. So thank you so much. Appreciate you
Thank
guys.
you. Bye.